And good afternoon, everyone. And on behalf of Director Allen, I'd like to welcome you to the DC FOIA Officer Training Series. This is a hybrid training session, so we have a few folks in-house with us, but most of you are actually online. So thank you all for attending. We appreciate the effort that you're making, and hopefully we can teach you something that'll be helpful to you. And in the end, you can teach us some things as well. I'm Neal. I'm the Chief Counsel of the Office of Open Government. And the name of the series today will be DC FOIA Appeals, Analysis, and Insights. Before we get started, as always, I would like to introduce who we are and what we do. We are the Office of Open Government. It is a component along with the Office of Government Ethics. On the other side of our building is under the Board of Ethics and Government Accountability. OOG is overseen by Director Allen. And it began operations in April of 2013. I started in DC government in February of 2013, so I'm just a little bit older than the agency. OOG interprets and monitors compliance with the Open Meetings Act, the OMA. This particular law requires that public bodies provide proper notice of access to and detailed records of their meetings. We also advise on the Freedom of Information Act, the DC Freedom of Information Act to be particular, which concerns the transparency and the availability of public records. OOG provides guidance, including formal advisory opinions to public bodies on compliance with the OMA, which we will not be as much concerned with today as we will with the FOIA. But also, OOG also conducts trainings and outreach and can also enforce the OMA on the basis of complaints from the public and its own investigation. And as a last resort, we do have the ability to sue public bodies in the Superior Court for injunction, declaration, and civil fines. And we do have a handy-dandy trial attorney named Brandon Lewis that helps us take care of that. So not that we have to enforce it that much, but if we have to, we have the weaponry to do it. Anyway, that is always a last resort. So just to keep that in mind. But today we won't have to worry so much about the OMA issues. We would like to deal with the DC Freedom of Information Act. So this particular presentation will focus on particular aspects of DC FOIA Appeals, the process itself. And at the end, I will also go over a few selected appeals decisions from the MOLC over the past year. And I would like to thank Sean Nolan, who is the senior attorney advisor over at the Mayor's Office of Legal Counsel. He and I worked together once before. He is an outstanding attorney and would be absolutely remiss if I did not thank him for the help that he gave me in getting some of these cases together to present to you today. So if you're listening, Sean, thank you very much. I truly appreciate you. So the first question is, what is a DC FOIA appeal? Quite simply, it's the public's right to access records held by DC public bodies. Appeal is not a second records request, so in effect, it is not a second bite of the apple. What it does is it challenges an agency's denial, redaction, defeat decisions, failure to respond, or inadequate searches. And all of these are issues that I will go through and that you will see as we begin to talk about some of the cases that are going to be presented here today. So the objective of this presentation is to help agency FOIA officers to recognize appealable problems and assess the best route to disclosure. In understanding what the things the MOLC is looking for when it is appealing some of the decisions made by the agency, it would help some of the agency FOIA officers to maybe avoid making some of the mistakes that can get you appealed and have the MOLC tell you how to do things differently, and also give you an insight on what kind of things would be helpful to the requesters. So the legal and the procedural foundation for DC FOIA appeals is found in DC Code sections 2-531 through 539 and 1 DCMR sections 400 through 417. A lawful denial letter should contain the precise exemption, factual reasoning, responsible official, and appealable notice. And the reason I'm talking about denial letters is because, again, this is a presentation on MOLC opinions and MOLC decisions. So obviously, if you're not talking about denial letters, you're going to be talking about MOLC appeals. So that's why we're talking about denial letters and things of that nature. It should also explain constructive or deemed denial when an agency misses its statutory deadline. We'll talk about those deadlines in the presentation. So before we get into the MOLC job and what they do, we're just going to do a really quick recap on DC FOIA, just to kind of bring you back up to speed. I know that DC FOIA officers, all of our agency officers, do this stuff on a daily basis, but we may have some new agency officers or people who are interested in doing DC FOIA for the agency. So this will give you just a quick rundown, again, recap of the things that are essential for processing FOIA appeals, or at least FOIA requests on the agency level. The first thing we want to go through is the normal request response cycle and the timeline for DC FOIA requests. So the normal request response cycle for a DC FOIA request is a 15-day statutory window. Now, this window, of course, can be extended by an additional 10 business days for unusual circumstances, or up to 25 business days when the request involves body-worn camera footage. If this 15-day cycle, this statutory window seems short, that's because it is. That's not a whole lot of time to process some of these. And believe me, not just Office of Open Government, but several other FOIA advocates and other people are trying to work to get that change, to get that 15-day window extended. It's a very short period of time. So believe me, we definitely sympathize with all the FOIA officers and anyone else that has processed these. So the submission and intake cycle goes a bit like this. You have the filing, and that's when the requests are submitted online via the DC Public FOIA portal, or by email, or by mail, or by fax. I know it's hard to believe that we still allow for faxes, but believe me, it still happens. You'd be surprised. I actually got a request for a recommendation. I actually got a couple of requests for recommendations, personal and professional recommendations the other day, and the request came in those refillable PDF files. You see, you fill those things in, and after you're done, you're supposed to shoot back to the person who requested it. Well, it didn't work, as I don't think they ever do, but it did not work. And I contacted the person who sent it, and they said, well, what you can do is you can just fill it out manually, and you can fax it to us. So faxes do exist. This particular requester was actually a request for a job recommendation to a IT company, and they wanted me to fax them something back. So I told my friend, don't go there. So the receipt date, that's the statutory clock that starts the day the correct agency FOIA officer actually receives the request. And tracking is the agency logs the submission and assigns a tracking number. The tracking number, of course, is not just to identify that particular request, but also to reference when you're talking to the requester about their case and to give them information regarding the status of the cases. So again, we talked about the processing window. So the initial deadline is a 15-day deadline. That's excluding weekends and holidays. That's for standard records to issue a determination response by the agency. Body-worn camera footage is an exception, and that's a 25 business day if the request specifically targets body-worn camera recordings. Unusual circumstances extension, agencies can claim an extra 10 business days or 15 extra business days for body-worn camera footage by notifying the requester if records are voluminous, scattered, or require interagency consultation. And we know that those things happen. Oftentimes you get requests that are extremely voluminous, sometimes requests that require you to get in contact with other agencies in order to get records, and any number of different things that could happen that could cause you to not be able to meet that deadline. And so in those situations, you would request, at least claim an unusual circumstances extension. The resolution and delivery of request. So a determination is made by the agency. The agency provides a response letter, either granting the request, denying access to the records that have been requested, or providing redacted records or citing applicable exemption. 24 is 19. I'll not change that. We do know that federal FOIA has 9 exemptions. DC has considerably more. 24 of them, depending on how you count them, but it could be 19 depending on how you count. It depends on how you count these exemptions. Then you have the deemed denial and the appeals. If the agency fails to respond within the legal time frame, including all the ones we brought in, including all of the extensions, the request is considered a deemed denial, and this allows the requester to file an administrative appeal with the Mayor's Office of Legal Counsel or the MOLC, or to seek judicial review. So now we go to the appeal process and analysis. Sorry. Oh, I'm sorry.
The question about,
Sure.
all right, so I'm Eric with OAG.
Hi.
And so would it be reasonable for an agency, when we have to go to Octo to get emails, right? Would it be wrong for us to adopt sort of an automatic policy that the moment we send that request out, like to Octo, we pause the statutory clock? Because, you know, I think Octo is working as fast as they can to collect emails, but it takes 10 to 15 days just to get the request back.
Unfortunately, I do not believe a automatic pause of the statutory clock is allowable.
Okay.
It's allowable under the statute.
Okay.
You can claim unusual circumstances,
Yeah.
which of course you're going to probably still likely run over.
Right.
Okay, and that's fine. And we're going to discuss what happens even if you run over.
Okay.
But for now, at least not in the statute, it's not on it.
Okay. So,
Right, Jones?
Yes.
Anthony? Okay, I got a few FOIA experts in
okay,
here.
no, more than enough. So I still wonder if we might try to just explain to the requester, hey, here's what we're dealing with here, and get them to.
Absolutely.
Right.
And as you said, absolutely important. And I'm so happy that you made that point. Later on, in the presentation, we're going to talk about those situations and the reason why communication is so important. Just keeping in touch with the requester, letting them know what's going on. Most times that as well kind of keep them at bay.
Yeah.
Because rightfully so. I mean, many times they've made a request, and for unusual circumstances or a need for an extension or whatever the case may be, you just can't get it to them. Mm-hmm. And the important thing is just to, keep the lines of communication open with the requesters so that they can tell them.
Been there.
Been there. Now, the appeal process and the analysis. So there are basically 2 paths to the appeal process after a request has been denied by the agency. Of course, most of them are going to be the first one. So most executive branch public body records requester may petition the mayor through the Mayor's Office of Legal Counsel, which handles these types of administrative appeals. In special circumstances, the DC Counsel records are being requested, or records from the Office of the Attorney General. Those records can go to a distinct direct to Superior Court path. So they can sue you immediately. All right. Note that the administrative appeal determination is due in writing within 10 business days under DC Code 2-5. So the question is, and this is very important for the agency FOIA officer to know, is what exactly is it the MOLC looking at when they get these appeals? So I believe if you understand better what things and what particular ways they dissect or analyze these particular appeals, it will probably help you to better answer the appeals or not make the mistakes that would get you appealed. So the MOLC is usually reviewing and it analyzes the agency decision. It compares the request with response. Quite frankly, they just want to make sure that the agency's response is actually, lines up with what the requester requested. It identifies every withheld category, identifies all the redactions. It lists every cited exemption that the agency claims. and it determines whether the agency explained why the exemption was applied. It asks whether non-exempt portions could be separated and released, and it evaluates the adequacy of the agency's search. And all of these particular decisions, all of these points that I made, we are going to discuss more in depth as we go through the remainder of the presentation. Review for common disputes types. There are no records, overly broad privacy redactions, law enforcement claims, attorney-client work product claims, deliberative process claims, all of the privileges and missed deadlines are some of the things that the MOLC will be looking at in order to determine whether the agency did not fulfill the request adequately. So some of the possible outcomes in terms of enforcement and possible litigation. The MOLC can affirm the agency's denial. So if the agency denies based on exemptions or whatever the reason for the denial, the MOLC will take a look at it and will make a determination whether that was a correct exemption or whether that was a correct denial of either all the records or parts of the records requested. Order disclosure. Sometimes it's just a situation where the agency just simply, just doesn't disclose the request. We'll run through some of those and some of the cases we're going to be talking about today. Ordering a supplemental search, remand for reconsideration or partial disclosure. In a situation where, again, we're talking about the counsel or OAG, where it's direct to the Superior Court, or when the appeal process has already taken place on the MOLC level, and the requester does have the right to go to Superior Court. You could have a suit for injunctive or declaratory relief in DC Superior Court. And in court, the public body bears the burden of supporting its withholding. So if there were withholdings based on certain exemptions or whatever the case is, then the burden is on that public body to prove to the court that it withheld those records correctly. The case is reviewed de novo, and the court may inspect records in camera. Also, one of the things that the court will consider is potential attorney's fees and costs for requesters who avail in whole or in part. So we're going to go through 3 cases, and here are some of the appeal decisions and the recurring lessons that you can learn. I tried to pick out several. Sean from the MOLC sent me a few of them, but I wanted to just kind of extract a few that I believe that most of our FOIA officers encounter when they're dealing with some of these appeals. That is something that certainly occurs more common over at the MOLC, and so yeah, he thought it would be a good idea for me to take a look at a few of them. These are the ones that I came up with. So here is one case is 2026-230, and the basis of this case is that corporations do not have a privacy interest. In the 2026-130-132, the lesson is when no decision can be dispatched within the applicable time limits, an agency shall nevertheless continue to process records and to communicate with requesters. And that's kind of what we're talking about a little bit as well. In opinion 2026-219, DC Code Section 2, 530-534-A3A is applied to withholding investigation records from enforcement agencies other than police. So we'll deal with our first case. This appeal, number 2026-230. Now this case discusses FOIA appeal decision related to a requester and the Office of Unified Communication, or OUC. This particular case illustrates the very complex and tricky balance between public access to information and an individual privacy right. The Freedom of Information Act, FOIA, is designed obviously to give the public the right to access records from any federal agency. In DC, the local law is modeled very similarly, and it promotes transparency in government operations. However, there are specific exemptions that exist to protect personal privacy. So as background to this case, on May 7th, 2026, the requester submitted a FOIA request to OUC, and they were seeking all of the records related to calls, for service at this specific location, 732 734 15th Street Northwest, and requested those records over a period of time. Excuse me. So OUC denied this request on May 15th, citing privacy concerns related to the address, which in this case was identified as a private club. So OUC's reasoning was that releasing records related to calls relating to calls at this private club would constitute a quote clearly unwarranted invasion of personal privacy under DC Code 2-534A2. And they emphasized that privacy rights pertain to individuals, and since the requester was not the caller, remember the caller was someone who called in for information, and the requester was a different person. And since the requester was not the caller, the information could not be disclosed. So, of course, an appeal was filed at the MOLC by the requester. On May 26th, they filed that appeal challenging OUC's application of the personal privacy exemption. The requester argued that a private club does not have personal privacy rights, and that the privacy exemption could not be and should not be applied to business entities or to their addresses. The requester also questioned the adequacy of OUC's search for responsive records, saying that citing caller privacy did not justify a complete denial of all of the records, which is basically what OUC did. They just applied a blanket exemption, and that is one of the things that the requester challenged. Now, this raises an extremely important question about how agencies are required to conduct their searches. So the legal framework of this particular and the public legal framework of this case obviously relies on public policy. Obviously, the public policy of the district is to emphasize that citizens are entitled to full information about government affairs. And DC Code Section 2-531 supports this right, while Section 2-532A allows public inspection of records subject to specific exemptions. So as it relates to public privacy exemption, the exemption cited by OUC, DC Code Section 2-534A2, it protects records of a personal nature. It requires a careful balancing of individual privacy against the public interest in disclosure. The courts recognize that a substantial privacy interest exists for personal identifying records. However, it is crucial to note that corporations and entities do not possess personal privacy rights under FOIA, under DC FOIA. So the MOLC decision referenced important legal precedents indicating that privacy protections apply to individuals and not to corporations and not to businesses. So as the owner of the property in question was a corporation, this particular fact weakened OUC's justification for withholding those particular records. So there was also an issue of adequacy of search. That is one of the other issues that the requester took issue with and it appealed upon. So in evaluating whether OUC conducted an adequate search, not enough to speculate about the existence of the records. The records may or may not exist. The agencies are, however, required to make a reasonable determination of where records might exist and thoroughly search those locations. Also, OUC's reasoning regarding caller privacy did not sufficiently blanket this particular issue. So the conclusions and the recommendations at the end of this particular case. So ultimately, the MOLC remanded the case back to OUC, instructing them to revisit their search for responsive records. And they also had to disclose, OUC also had to disclose any non-exempt records and to provide a detailed explanation of their search process. The decision in this case really underscores the need for transparency, of course, especially when corporations and corporate entities are involved. It also illustrates the ongoing tension, so to speak, between privacy rights and the public's right to know. So it's essential for citizens to understand that these particular dynamics and to advocate for transparency in government practices, but it's also very important for agency FOIA officers to understand this distinction and understand that this balance does have to be has to be undertaken, has to be exercised when making its determinations, making its decisions rather. So the second case that we're going to take a look at is a MOLC appealed opinion 2026-132. This particular FOIA appeal decision is regarding a request to the Metropolitan Police Department, MPD. This case emphasizes the public's right to access government information and the responsibilities of agencies in responding to those requests. So a little background. On January 13th, 2026, the requester submitted a comprehensive FOIA request to MPD related to a specific incident identified by a CCN number. And as you know, a CCN number is a central complaint number. This is a number that is used for tracking by MPD and in the Office of Unified Communication. And if you ever have had to deal with trying to request records from MPD, they will always tell you that they needed it, the CCN number. And then you have to contact OUC for the CCN number. You better hope OUC has that CCN number available, because if they don't, then MPD is going to say, you need to go back to OUC, because they're not going to be able to do anything with those records. So we've seen that a number of times. Whether it's a good system or not, it's not for us to say, but that is the process. So after the request sought various records, matter of fact, it sought quite a few records. Again, it said the submission was comprehensive. The requester was looking for reports, supplemental reports, witness statements, both written and recorded, photographs, video recordings, audio recordings, and diagrams, officer notes and memorandum, and they were even requesting scene measurements and analysis. So upon receiving this request, MPD initially asked the requester to provide additional information, particularly identification of the individuals that were involved in this particular case, which the requester did provide. However, despite further clarification and additional information that had been provided by the requester, MPD still failed to respond adequately. So on February 23rd, the requester filed an appeal with the MOLC, and they asserted MPD had not provided any response to their request. So the initial takeaway here is the importance of timely communication and accountability from the government agency, and I'll speak a little bit more about that at the end of this case. The legal framework for this particular case, the public policy, of course, is that all individuals are entitled to a complete information. According to 1 DCMR, that's 401.1, the responsibility for responding to a FOIA request lies with the agency head. I guess in this case, the police chief. So when no decision can be dispatched within the applicable time limits, an agency shall nevertheless continue to process the request and inform the requester of the reason for the delay, the date on which a determination may be expected, and the right to treat the delay as a denial with the right to appeal. This goes to what we were talking about earlier about continuing to keep the lines of communication open, but to also continue to process the records. Even if the deadline is passed, there still is an obligation to process those records and to keep the lines of communication open, giving the requester at least an update on the status of their request. So in response to the requested appeal, the MOLC noted that MPD had not complied with the response. And so the office decided to remand the case back to MPD, instructing them to adhere to the requirements set forth in the regulations and to produce any non-exempt records as soon as it's practical. Now, the big takeaway from this case, again, is that if a request can't be answered within a statutory time deadline, the FOIA officer should keep the requester informed. Trust me, this will definitely avoid any issues with the MOLC, and it most certainly will avoid any of the issues with the requester. So if you're avoiding issue with requester, then you're gonna probably avoid MOLC. Some requests take a lot of time, as we were talking about earlier. There are a lot of complexities. Sometimes you have to deal with different agencies, and sometimes you have voluminous records. So the most important thing really is to be as transparent with the requester as possible, to let them know the status of the case and to continue the process. So when no decision can be dispatched within the applicable time limit, agency still has to continue to process the record. I'm going to be sharing this PowerPoint, and as you can see, I put in here small writing, key takeaways, and I put that in there because I think it's important to be able to just remember these things. If a request can't be answered within the statutory deadline, you should continue to keep the requester informed and give them the reason for the delay and the expected time frame for the completion. We often have to do that even when we're dealing with information, because that's basically where we are the people who give the information about DC FOIA. Our director writes advisory opinions. Our attorneys have to deal with these requests for information, and oftentimes even we run into issues where we have to consult other agencies, or we have to do the investigation. Sometimes the investigation requires us reaching out to the agency itself to find out what went on, what happened. And one thing our director encourages us to do is to just keep the lines of communication open with the requesters to let them know, hey, this is what's going on. In the case of agencies where you are often having to try to find records and information, just make sure when you contact the requesters that just give them a reasonable time frame, and be reasonable not just to the requester, but be reasonable to yourself. Don't say, I'm going to have all these records to you in 48 hours, and you got 250,000 paper records to go through. Right? Just don't do it. So be reasonable to yourself. Give yourself, adequate time, reasonable enough time, but just keep the lines of communication open. That's the most important thing. So the last case that we're going to look at is FOIA appeal on the MOLC, case 2026-219. Now, just in case anyone thought that I was picking on MPD and OUC, this case actually involves us in the Bar of Center. It involves our office. This is a recent MOLC decision regarding a FOIA appeal that was filed by a requester who, on May 25th, 25, submitted a FOIA request to the Board of Ethics and Government Accountability. Us, baby. The requester sought various investigative materials related to a case that had been investigated by our office, particularly the Office of Government Ethics. We're the Office of Open Government. We do different things. They're a different agency, and so they do all that fun stuff, and we let them enjoy it. Particularly focus on events followed by an EEO complaint by a different person other than the requester. So the requester wanted certain information. They requested preliminary investigative material. They wanted internal communications. They wanted evidence collection material, and they also wanted enforcement decision material. So on July 11th, Vega responded to the requester. However, they denied several requests and stated that they had no responsive documents for others. The reasons cited included various exemptions under DC code, which I will discuss in a few. And also, there were exemptions and also some confidentiality issues because some of the documents were classified as confidential due to ongoing investigations. So in the requester's appeal, which they filed on July 16th, 2025, they raised several significant concerns. They challenged the adequacy of Vega's search for documents. They questioned the applicability of the exemptions used to deny their request. And additionally, they brought up other more broad issues, including allegations of retaliation and discrimination, which the MOLC determined deemed were outside of the FOIA context. That is something that happens very often. Anthony can tell you a lot. Anthony is our FOIA officer and always getting requests. And sometimes they want us to talk to the president about some things that he did or talk to the mayor about things they did, or this problem that's going on with the stadium or any number of things that are way outside of our jurisdiction and our line of power. So that's just one of those things where you just simply say, outside of the scope of our duties. And most times the MOLC understands that and they will support that. So the legal framework for this particular case. So Beta cited several exemptions under DC Code 5, that section 2-534. They cited the section 534A. Now this protects investigatory records compiled for law enforcement purposes, but only if releasing them would interfere with legal proceedings, deprive someone of a fair trial, or to disclose confidential source or endanger law enforcement personnel. Also withheld information based on section 2-534A4, interagency or intra-agency memorandums or letters that would be available by law to a party in litigation with the agency, which incorporates all of the privileges, the deliberative process privilege, attorney-client privilege, and the attorney work product privilege. It also utilized exemption 2-534A6, which protects information that is specifically exempted from disclosure by another district or a federal statute, such as a student privacy under FOIA and medical records under HIPAA. So this requester, in addition to these exemptions, remember the requester also challenged the adequacy of Bega's search. So under 1 DCMR section 402.4, the MOLC said that adequacy is measured by the reasonableness of the effort in light of the request, and additional information may be available by submitting a request to Bega that succinctly describes specific records sought, and it encouraged the requester to do so in this particular case. So in this, what this is essentially saying is that the standard is not whether documents might exist, but whether the search was reasonable. Bega clarified that they found no preliminary investigation documents since only a formal case was considered in this instance. So the legal framework in this case, in determining whether an agency conducted an adequate search in response to a record, the test is not whether the documents might exist, but whether the agency search is responsive. Agency search for responsive document was done adequately, and this is the case law, a Supreme Court case. Again, I will be giving you this PowerPoint presentation, so you'll have these citations and these laws. So ultimately, the MOLC rendered the conclusion, the final decision. They decided to deny the requester's appeal. Now, this final decision underscores the balance again between transparency and the need for confidentiality in certain types of government processes. And now, so that includes the cases. Now we have questions, but before I ask or answer any questions anyone might have, and I'm not sure whether there were any questions that were in the chat. Attorney would have been honest with the chat to make sure there have not been any questions.
There are not.
Okay, you have a question?
Going back to that corporate interest case, let's say this is a private building and I work here and there's an emergency situation where I dial 911 on my personal phone and somewhere along the line, someone requested that 911 call. How would you weigh my own personal interest as an individual versus the corporation that I work for?
You work for the corporation, and this call is regarding
An emergency that happened in that building.
emergency that happened in that building, and it's the private corporation's building. Well, it would be weighed. The interest, obviously, what your personal privacy interests are is balanced with the public's need to know what that was. I mean, it'd be hard for a FOIA officer to do that, but I mean, our thought always is err on the side of exempting, right?
Well, yes, and to the point, our colleague Tracy Ferguson over at OCFO mentions in the chat, the corporations do have privacy rights exempting some of their information from disclosure. Again, especially the proprietary and business and financial information, bank and routing, et cetera. But when it comes to something like in this scenario, I think erring on the side of withholding or redacting. I mean, the policy is transparency to the maximum extent possible, but the point of exemptions and the ability to apply privileges or redactions is that there's a reason for it.
Right. Remember, exemptions are construed very narrow. There's it's always favorable. Of course, we're always looking favorable for disclosure. So, I mean, as a FOIA officer, apply the exemption if you think there's a chance. It's better to release it later, when you have to, rather than releasing something that you shouldn't release and you can't take it back. Now, as we've gone through some of these cases, is there anyone either online or anyone here that's actually dealt with some of the issues brought up in this? I mean, obviously,
I used to be the OEC FOIA
anyone
officer.
else? Has anyone else had any of these issues? I hope not. I mean, I really hope that you've had a really easy time being a FOIA officer and you've not had to deal with, any MOLC reprimands. So if there are no other questions, I just want to say thank you very much. I think I've given you quite a bit of time here. And so again, I would like to thank all of my colleagues. And I'd like to thank all the FOIA officers who have come and who've spent time. If you're here online, thank you so much for joining in. Again, this is our contact information. Kel Allen is our director. I'm Neal, I'm the chief counsel. Our attorney advisors are Joan Loma and Anthony Skirbo, who's also our FOIA officer here. Brandon Lewis is our trial attorney. Kevin Brown, who's actually not here, but he is helping out from afar somewhere. And thank you very much, Kevin. You fixed a big problem for us right off the bat. And Kimberly Brown is our paralegal specialist. We appreciate each and every one of them and all the support that they've given me for the presentation. If there's no other question, then yes, John.
There is a comment.
Okay.
I know you're familiar with this because we did an opinion.
Speak a little louder, Joan.
So it's from Zachary, that this is less a question and more a comment. MOLC decisions on FOIA appeals from before February 2nd, 2021 are searchable by keyword. MOLC decisions on FOIA this date not. Can beg or encourage MOLC to fix this. Yeah, so that's.
Sorry, so the question is, can we encourage MOLC to, I'm sorry, Anthony was just.
I was a little low too, so I'll turn the volume up.
Okay.
A lesser question and more of a comment. MOLC decisions on FOIA appeals from before February 2nd, 2021 are searchable by keyword. MOLC decisions on FOIA appeals from after this date are not.
Oh.
Can beg or encourage MOLC to fix this.
That's outside of our pay grade.
But if anybody can help with the use.
Well, I will simply say that, the MOLC, and this is not to, jump on anyone's defense, but the MOLC, just like anyone else, has, voluminous amounts of records. I'm sure that they are doing their best to make sure all of their records are searchable. Just as a matter of fact, one of the things that we're doing here is we actually have one of our interns, Maurice is back there, and working him hard to try to actually help with some of the indexing and making those MOLC records more searchable for us. So when we have to refer to some of the MOLC opinions in the opinions that we render, it'd be a lot easier. So, I'm sure that the MOLC would like to be able to get all those records searchable, and I can tell you that is something I know that they're working on, because it's not the first time that that particular issue has been brought up. Anything else? Any other questions?
So do you have anything in your slides about the upcomings?
Oh, Anthony's going to tell you about upcoming. He told me to remind him, but I didn't write it down, so he can tell you.
So for the next 2 weeks, we have our final 2 webinars in the series. Next week, Director Allen is going to be presenting on the impact of AI and other new technologies on the process. And then in the final week, we will have our normal closing session, which will be not reported and not available as a deck. It will be for FOIA officers only, with the two lead attorneys from Civil Division over at the Office of Attorney General regarding preparation and defending FOIA cases. Additionally, today, we welcome our colleagues, both present and virtual, to join us for our social at Blackfin anytime after about 4:30 or so. Blackfin, for those who don't know, is located at 1620 I Street, very close to the White House. We look forward to seeing anyone who's able to make it, and we send our best to anyone who is unable to make it.
And we will occasionally, if this was my turn, Anthony had the last in-person after the presentation, we were able to go over to, where did we go last time? We went to the stands, and we had a great time. It was a wonderful opportunity to speak with FOIA officers, get an insight on what issues they deal with in particular. It was really interesting, and it was a great time, just to kind of, unwind and put names to, faces to names. And so we're going to do that again this evening, and I guess we'll do it again soon. I'm not sure when the next in-person is going to be. I volunteered for this one, so I think Brandon and Joan, you guys are up next sometimes. We look forward to seeing you really soon. But other than that, thank you everyone who had joined us. We really appreciate it. And if you are able to join us over at Blackfin here in the next 45 minutes or so, then we would appreciate it. Thank you all very much. And I'll leave it open for a little while. If you do have any other questions, again, you have our contact information. Please feel free to email any one of us with any questions or comments or concerns that you might have. Thank you all so much.